So before we talk about guilt or innocence, let us ask a question. When does interview stop being a conversation and start becoming a criminal charge? Because right now, the situation is sitting quietly inside El-Rufai's case. But amid the emotional public discourse, Inibehe Effiong's intervention has introduced a legal perspective, and that is the reason for this video. But first, let us get the context of this conversation. It's no longer news that El-Rufai has been on the trends for the past days. So, Malam El-Rufai is reportedly in custody and he has been charged with cybercrime. But according to the charge before the Federal High Court, the allegation stems from the statement he made during an Arise interview on the 13th of February 2026. Now, let us break down so that everybody understands and follows clearly because this is where law and interpretation collide. What does the charge actually say? In simple terms, count one. The prosecutor suggests that El-Rufai admitted during the interview that he and others unlawfully intercepted, meaning wiretapped, the phone communications of the National Security Advisor, Niu Rabadu. So this is a very serious accusation because unlawful interception of communications is classified as cybercrime. The count two goes further. It claims that El-Rufai stated he knew someone who unlawfully intercepted Rebado's communication, but then failed to report the person to the authorities, meaning that even if he did not do it himself, the charge says knowing and not reporting is an offense. But human rights lawyer Inibehe Effiong reviewed the charge, and that is the basic for this conversation. So let's explain them without legal jargon. So Inibehe points out something technical but interesting. He said that under Nigeria's National Security Agency, the agency legally created is called State Security Service, that is SSS, not Department of State Services, which is DSS. In other words, Inibehe is saying SSS is the official statutory name, while DSS is commonly used operationally. So his argument is about legal precision because in criminal law, technical accuracy matters. So if the charge mentions an entity not written exactly as created by law, a defense lawyer might question the drafting. But here's the practical reality because courts often treat DSS and SSS as referring to the same institution since everyone understands they mean the same agency. So this may not destroy a case, but from a strict legal standpoint, it remains an interesting observation about drafting accuracy. It's like someone legally named Michael Okafor, but widely called Mike Okafor. So if the document says Mike instead of Michael, does that automatically collapse the case? Another concern raised by Inibehe is that DSS is primarily an investigating agency, meaning that they investigate, they gather intelligence, but prosecution usually flows through the Attorney General, Ministry of Justice. So the legal question becomes, was this charge properly filed? Under whose prosecutional authority? Because procedural issues sometimes matter greatly in court. And the most interesting part is the third part, which is, was this a confession? This is where things get interesting because the charge appears to treat El-Rufai's TV's comment as if it were a confessional statement. But under the criminal law, a confession typically requires clear admission. It has to be voluntary and it has to be properly cautioned. That is to say, you have situations like you are obliged to say nothing. You have to be informed that this is a confession. So, can a TV interview without caution automatically become a confession? Because political speech is not automatically criminal confession. So, did El-Rufai actually admit guilt? This may be the strongest legal debate because El-Rufai, according to the report, did not say, I wiretapped the NCA. Instead, he allegedly implied someone else intercepted communications and informed him. So the distinction is crucial because legally, alleging something happened and admitting you committed it are two different things. Also, repeating information does not exactly mean you're confessing to participation. And so, Nigeria's constitution protects individuals from being forced to give evidence against themselves, meaning that no one can compel you to confess. And also, silence cannot equal guilt, even when the authorities suspect wrongdoing. So this conversation is bigger than personalities because this case touches on how political speech is interpreted, whether media interview can become criminal evidence, the line between the allegation and the confession, and most importantly, the procedural precision in prosecution. So, if public interviews are now being treated as automatic confessions, then every political conversation becomes a legal minefield. Because the law is meant to be blind. But in Nigeria, we wonder whether it always is. And that is why, beyond this case, consistency in applying the law remains the real test. It is a truth at a time. Take care and have a nice day.